So generally speaking, this is about lethal force in the law. It's really compliant with everything throughout the United States. I'm going to bring up a few examples of different state laws, not because I want you to know them, but because I want you to learn that they're all different. And we can't assume the laws of our state are the laws of Pennsylvania, are the laws of West Virginia, and Ohio, and Indiana. Everything's different slightly to a certain extent. And I didn't know, or I thought it was the same, doesn't work for us at all when we're talking about things like that. A little bit about who I am. I've been a criminal defense attorney now going on 25 years. I've litigated everything. I've defended just about everything that you can possibly imagine in my career. And for the past 11 years, really, I became sort of a self-defense attorney. I deal with almost 100% things related to firearms, firearms law, firearms rights, our Second Amendment rights. I do a lot of free work for the National Rifle Association, referral work for Buckeye Firearms Association in the state of Ohio. I've been a Second Amendment advocate for probably just about as long as I could put a sentence together. And I don't know why. I grew up in a farm in Pennsylvania, and we never didn't have firearms. It was always a part of the fabric of who I was, and so I can still remember the phone call I made to my father when my freshman year of college when a co-ed told me I didn't have a right to have a gun. And what do I need a gun for? And I remember I said, Dad, you're not going to believe what this person just said to me. From a small town, Pennsylvania, grew up on a dairy farm, so you know, that's always something that always sticks with me. I've been an NRA Life member. I sit on the NRA Board of Directors. I'm a leader of Buckeye Farms Association in Ohio, where Buckeye was formed because 11 years ago, we didn't have a right to conceal carry. And one of the proudest things I've been involved with is the FASTER program that we have. It's Faculty Administrator Safety and Emergency Response Training. We train combat casualty care for teachers in case the bad guys get in and the first aid isn't there. And then most importantly, if the schools want to allow school or firearms in the school safety zone, we train teachers, we train janitors, administrators to carry firearms and to make sure our kids are protected. After Sandy Hook, we can all realize we knew what the answer is, and truly the only way to protect our kids from a bad guy with a gun is a good guy with a gun, because seconds counts, and that's why FASTER came about. In Ohio, legally, a school board can make a decision to allow firearms in a school safety zone, and so we took that and ran with it. We were ridiculed in the beginning by the media, mainstream media, because they told us that we would never get 23 teachers to sign up for this. Well, within 2 days, we had 1,400. And the program's been going on since that, from the beginning. And it spread to Pennsylvania. I spoke to the Pennsylvania Senate a few months ago. It's spreading to Colorado. California, even parts of California, are allowed to arm their teachers, so we're still doing that. And then, of course, I co-founded Second Call Defense. As an attorney, the reason why Second Call Defense came about was purely and simply because I'm selfish. I was getting sick and tired of spending Super Bowl Sunday in jail. Because people don't realize a lot of times, my wife always joked and said that I've spent more time in jail collectively than my clients. Because if you don't have money for bond or bail money, guess where I am preparing you for your trial or preparing you for your hearing? I'm in jail sitting right beside you. No matter how nice of a chair they bring me, I'm still in jail, and I don't like that. And I guess that kind of sharpens my edge and makes me train and do the best I possibly can, because the feeling of being in jail isn't good. People don't have money. 73% of Americans now live paycheck to paycheck. With that being the case, who has $10,000 cash in their nightstand for a $100,000 bond? And that's probably going to be the minimum, even if you brandish. After going door to door one night with a 23-year-old woman, a young mother with 3 kids under the age of 7, and her husband, of 23-year-old husband, crying in tears, I knew he was going to be different. He was arrested for brandishing legally and properly. I knew in my heart he was. On a Friday night, Monday morning as arraignment, he wasn't going to be the same person. And at that point in time, I said, there's got to be a better way. He was overcharged. The police officer didn't know what to charge him with, so he charged him with felonious assault simply for raising a firearm and saying, my God, please stop, don't, when he was being attacked. The only problem and mistake that he made is he tried to drive to the police department to tell him what just happened, when the true bad guy got on his cell phone and called the police and blamed everything that just happened on my client, who became my client. Luckily, we're all on film, always on film, and it happened in a car wash parking lot. And after the first hearing, I remember the judge telling me that, Sean, we're always on film. And I went to the car wash and I said, hey, do you have any film or security cameras? She said, yeah, we have them all over. I said, do you have the film from last Friday from 4:30 to 5? She said, sure. She burnt me a disc, and it happened exactly when my client said it happened. With that kind of proof, the prosecutor said, not going to prosecute. The judge said, it still involved a firearm. I'm going to let the grand jury decide. So 5 weeks we're waiting for a grand jury to come back to tell this kid whether or not he was going to have to defend himself, against years in prison. And what was even sadder was this happened around 2008 when the economy was really starting to crash. He just got laid off, so he had to look for a job. And it's a law in Ohio, if you are charged with a felony, even if the charges are thrown out, that you can't seal the record for a year. So for a year, he had to explain why he was charged with felonious assault. And so things have consequences. And that's kind of why, selfishly, I started working to form second call defense. It took about 3 years. I still have my criminal practice, and now it's a self-defense practice for the last 11 years. That's principally what I'm involved with, going around the country, speaking to people, and making sure that we know our gun rights. And that's what we're here about today. Lethal force in the law. What are the consequences? Now, we all train ourselves to carry firearms. Some of us are thinking about doing it. Some of us have firearms in our home that we're going to protect ourselves with. One way or another, we're going to use a gun in self-defense. I always laugh at people, I don't carry a gun for self-defense, but do you have a shotgun you trap shoot with? Yes. But I'm not going to use that for self-defense. And I say, if someone enters your home going to harm you, what's the first thing you're going to do? And then they think. And so that's what this seminar is all about. When can we legally use a firearm in self-defense? I'm going to show a video real quick to kind of get you in the mood. It's about 3 cases that happened. One was in Arizona, and one was in Ohio, and one was in Iowa. And you just hear the facts of these cases, what happened, and then what happened, because not necessarily you had a bad judge or a bad prosecutor, but because you're in parts of the country that don't think like we do.
Harold Fish was a 57-year-old retired high school teacher in Arizona with a clean record and a license to carry a concealed weapon. While hiking, a man charged him, waving his arms and threatening to kill him. Harold Fish shot the man in self-defense. A jury found him guilty of second-degree murder, and he spent 3 years in prison and $500,000 in legal fees before the conviction was reversed. Karl Kozlowski was a 53-year-old Cleveland, Ohio man. While on an all-night crack binge, a convicted murderer broke down Kozlowski's door and began beating his girlfriend. Kozlowski shot the man with a .38 caliber revolver and was convicted of murder and sentenced to 18 years to life. It took 2 years for the verdict to be overturned and another year for Kozlowski to be released on a $10,000 bond. J. Rodney Lewis was a 49-year-old former law enforcement officer in Iowa with a permit to carry a concealed weapon. While driving home one night, he was confronted by 2 men, one a drunk convicted felon. After using his gun in self-defense, Lewis was arrested and jailed with bond set at $225,000. A jury found that he acted appropriately, but he spent 112 days in jail, lost his job and all his possessions, and found himself homeless and penniless.
When you think about those cases, Harold Fish, for example, did everything he had a legal right to do. In fact, the police department at that point in time, in an extended interview, said, Mr. Fish, we're not going to charge you with anything. You did everything you had a legal right to do. Unfortunately, it's not the decision of the police department. And if anybody's from Arizona or reads anything about self-defense law, it's a very famous case, and it changed all the laws in Arizona. What happened was he met up with a prosecuting attorney that was running for re-election and wanted to make a name for himself. And there was tape recordings and stuff that I got from trial and looked at. There's a lunch with the police department and the prosecutor. When the prosecutor told the chief of police and then the investigator, hey, I got to find a way to keep you out of the courthouse and the courtroom because you're going to screw up my plans for a conviction of Harold Fish. Police officer said, wait a minute. I'm not even filing charges on Harold Fish. He said, you may not be filing charges, but I'm trying him for second-degree murder. Harold Fish, it took 3 years from Masada Ube and some other pro-gun advocates to get him out. There was never a second trial. The second trial that took place was against a prosecutor for criminal prosecutorial misconduct. He was convicted, and he's the one that also served time in jail. But again, I remind people, things aren't always what they seem. Karl Kozlowski in Cleveland, Ohio, I'm familiar with that case because his conviction was so egregious, and there's so many errors in his trial that when it went expedited up to the Ohio Supreme Court, they immediately ordered his release. The Supreme Court of Ohio did. Well, the prosecutor didn't like that. Prosecutor dropped the charges, ordered his release, and immediately recharged him with something else. And that's why it took some more time for him to get out of jail on a bond, and the Supreme Court said, hey, wait a minute, we meant what we were saying. So even when you have a Supreme Court of the state, there are different factors that are involved. And of course, a retired police officer using his firearm legally, serves over 100 days in jail because it takes bond money to get bonded out, and things at times move very slow. So I'm never up here trying to scare somebody, but I always want to remind everybody, I've been carrying a firearm since I was 18 years old, and I always tell people the happiest day of my life was my 18th birthday in Corey, Pennsylvania. I registered for the draft. I was able to cross the Pennsylvania state line to New York State, which is only 4 miles away, and drink a beer, and I got my concealed carry permit. And so that's been a woven with factory. So when we think about lethal force, lethal or deadly force, is that force likely or intended to cause death or great harm? And note I said intended. Death doesn't necessarily have to be a consequence for you to be justified in using lethal force to defend yourself. Certainly, we can imagine that if we're using someone who's using a baseball bat against us, that we can reasonably assume that we're going to have some broken bones, and we can maybe also have a fractured skull and eventually die. But maybe we're not going to. So when we start to formulate the actions and the thoughts about when we can use lethal force in the law, it's a subjective test, meaning it's what I think, not what the rest of this room thinks until we get to the jury, and then we'll talk about that. So great harm in the form of a broken arm is enough for serious bodily injury to use lethal force because it's reasonable to think that something else could happen. So in the definition of lethal force, it's a force likely or intended to cause death or great harm. Now I always say, where have we read this before? If anybody's familiar with your own state statutes of when you can use lethal force or use self-defense against actions, and almost every state statute that talks about lethal force, you can always find the words, you're in fear or honestly believe of immediate unavoidable death or serious bodily injury. And now I'm going to focus on this for a while. If you reasonably and honestly believe that you're in fear of immediate unavoidable death or serious bodily injury, you can use lethal force. That is the defining line we're going to talk about. That is the key. And I add unavoidable for those states that have a duty to retreat. I live in Ohio where I have a duty to retreat. So even once I make the decision that I'm in fear of death or serious bodily injury or harm, right now what's going to happen and I can't do anything about it, I have to think about one more thing. Do I have a duty to retreat, and can I safely retreat? And we'll define what safely means too, because that's an important part of what we need to think about. That's why your response is to why'd you kill, why'd you pull your gun, why'd you brandish, why'd you do this in self-defense? It's always going to be the same thing. The answer is always going to be the same thing, because I was in fear of death or serious bodily injury. And it's that simple, but at the same time, it can be that difficult. And I always say, we're the good guys with firearms. If you're a concealed carry holder, for example, or you carry a gun because you're in a constitutional carry state and you have a constitutional right to, like we all do, we're the safest, most law-abiding segment of society. If you've ever looked at the uniform crime reports that the FBI put out on a yearly basis, they're usually a year and a half behind, and you look at the Center for Disease Control, the CDC statistics, I encourage you guys to Google CDC. They keep track of everything that happens. And when they take a look at this data, they realize, they look at the concealed carry holder now, at the United States, we are the safest, most law-abiding segment of society, bar none. So pat yourself on the back, shake each other's hand, because you make it easier for every other state that wants to pass concealed carry legislation to say, hey, we've been doing it for 11 years in Ohio and blood wasn't running in the streets. I looked at Pennsylvania when we started the Buckeye Farms Association and we're trying to pass concealed carry laws. You had people saying, oh, there used to be Dodge City, blood in the streets. And I said, well, they've been doing it my whole life in Pennsylvania. And that's not the fact. So congratulations, because you're part of that segment. And now when you get pulled over and a police officer sees that you have a concealed carry permit, especially with the states that it's on your registration, they're relieved if you talk to police officers. Because we know what they know about you. They know that you haven't been convicted of a felony. You know you're not drug abusers. What do they know about anybody else? And that's always my argument when I'm asked to visit board of directors meetings for stores whose attorney somewhere up the corporate ladder told them to put a no gun sign on the door. My first thing is, well, you're in the state of Ohio. There's a minimum of 500,000 people at any point in time carrying a firearm concealed in the state of Ohio. Why don't you want our money? You know, why are you keeping us out of your stores? And then I say, what do you know about your other clients? If I'm a concealed carry holder, I've never been convicted of a felony or a drug offense. I'm a good guy. And if anybody's familiar with United Dairy Farmers and a chain of convenience stores throughout the country, I went into a board of directors meeting, and that's what made the difference. They had several people that were in a concealed carry class that I taught, managers, and then it all came down to, why don't you want my money? And, you know, money talks, and so that was strange. But unavoidable will cover you even if you're in a duty to retreat state, and we'll talk about that in more detail. Now, if you provoke the situation, you started it, I pushed you, I punched you, and we started in a fight, and then I realized that I'm getting my butt kicked, I can't use the firearm for self-defense at that point in time because I started it. I always point that out. If you start it, you can't finish it with self-defense. But there's always a but because we're talking about the law. If I express my desire to end the conflict, if I say I stop, I give up, I don't want this anymore, and I try to walk away, try to break away completely with the situation, and that person keeps attacking me and keeps beating me, then at that point in time, I can re-engage and eventually use lethal force if I need to. But you have to clearly break away, and I always encourage people to talk to your local attorney, and seek out a local attorney and have a conversation with them. And I say local attorney because you need to know what your prosecutor's like, what the judges are like, and there's no better way to do that than a local attorney. And a lot of times, grab us. If we're at a Pheasants Forever banquet, if we're at a Friends of the NRA banquet, and you know they're a defense attorney, grab them. Trust me, we don't care. That's what we do, and we love to do it. And find out what's going to happen where you live. Now, some states have duty to retreat. It's almost evenly balanced. Actually, probably there's more states with no duty to retreat than not, but just make sure that you know what state you're living in. Most attorney generals will have handbooks that come out, and you'll understand if you have a duty to retreat or if you have a castle doctrine. You know, and I always point out, and I use this example not because I expect you to run out and learn Arizona law, but I was in Arizona 3 weeks ago doing this same seminar and helping instruct a concealed carry class. In Arizona, I found as I was preparing for it, they list 10 specific felonies where you can use a firearm in lethal force without being in fear of death. And I thought that was unusual. So really, Arizona was encouraging you to help them enforce the law. And if you talk to any sheriff or any police officer out there or police chief, they will tell you that this badge doesn't just represent the man standing behind the badge. It represents all of you out there. When I was in Colorado Springs helping with the recall efforts, the sheriff, I think it was Makita in Colorado Springs, said, I know that you're carrying concealed, and I want you to do that and encourage you because we can't do it ourselves. We're a small fraction of society, but you Americans, you are behind us. And that was pretty good to know. So in Arizona, for instance, if I interrupt somebody or see somebody who's committing an arson in an inhabited dwelling, I can use lethal force. If I walk in on somebody sexually assaulting a child, I can immediately use lethal force to stop that. And they say, no, retribution doesn't count here when it's over, and when it's over, you can't execute that person as a father no matter how much we may want to. But I point out that the laws differ from every state, so make sure you know what the laws are. And there's several websites out there that you can Google if you're traveling across the United States, and you can find out the right thing to do or the laws that you need to, to follow and abide by. So I was in fear of immediate, unavoidable death or serious bodily harm. Memorize it. Because I'm going to talk about why you're not even going to probably remember it unless you memorize it. We'll talk about the physiological and psychological impacts of a threatening encounter. You want to practice saying it. You know, honey, what do you want for dinner? I was in fear of death and serious bodily injury. What? I was in fear of death or serious bodily injury. You need to practice it that much because it's not going to come out naturally. That is the only reason, he hates me now because I'm moving, that is the only reason we can use lethal force is when we're in death, in fear of death, and serious bodily injury or harm. Everything else flows from there. So if I am in a duty to retreat state, once nothing happens until I make the decision that I'm in fear of death or serious bodily injury or harm. You know, it's interesting. When they start talking about passing stand your ground, oh, it's a dirty, hairy law. It's a license to kill. Well, no, it's not. Because nothing happens until you can make the determination subjectively or personally that I am in fear of death or serious bodily injury or harm. Then I can use lethal force. It doesn't matter if I'm in a stand your ground state or if I'm in a duty to retreat state. The only difference is, once I've made that decision and I'm in a duty to retreat state, then I have to determine if I can safely retreat or run away or hide or whatever it is. Note, safely is the important term here. When they apply the law of lethal force to safely in a duty to retreat, they're meaning that you can't be in any risk of any harm whatsoever, no matter what can happen. You know, people use the example, it's 32 degrees out, there's 4 feet of snow, and you're in your bare feet. Do you have a duty to retreat and run out your window? No, because you can't safely do it. So remember, safely is a key term. So in a lot of times I try to put myself in examples. Okay, what can I think of in the state of Ohio? A situation where I would be in a fear of immediate death or serious bodily injury, and that means it's going to happen right now. I can't call 911. I can't scream for help because it's right here, right now, that I would have a duty to retreat. Few and far between. I have 2 fake hips. I have titanium. My body's full of titanium. Folks, I can't run away from anybody. And so for me, subjectively and personally, that can't happen. So you got to remember, it's your decision. Now, a jury's going to judge that decision, and that's what we're going to talk about soon. You're in fear of death and serious bodily injury or harm. Because, folks, you want to memorize it and practice saying it, because if you don't, nobody, and I mean nobody, is going to know what's going to come out of your mouth. So you have to practice it. There's been a lawful shooting. In the background of a 911 call, you're bleeding like a stuck pig. I should have shot you again. Well, a person said that and had no recollection of saying it, and it was a shooting that actually took place in Pennsylvania. It was a self-defense situation. A husband and wife were unlocking their front door, and they were both attacked. The husband had just had open heart surgery, so was full of blood thinners. So he's thinking, I'm being beat, I'm going to bleed to death anyhow. The assailant is on top of him. He reaches for his firearm, struggles it, and gets to it and fires a shot. Hits the bad guy in the femur, shatters his femur. So the wife is on with a 911 operator, and what do we good guys with guns do? We're applying direct pressure to the bad guy who just tried to kill us. Listening to the 911 operator, telling him what to do and asking questions, and in the background, you can hear the true victim screaming, "You SOB, you're bleeding like a stuck pig. I should shoot you again." He had no recollection that that was said. The police came up and investigate what happened. They say, you know what? You did everything you had a legal right to do. The next day, someone listens to the 911 call, and they hear that in the background. And the prosecutor says, you know what? I wasn't going to press charges, but I can't explain what he's saying. Did he know that guy? Was there something that happened before this happened that I don't know about? And so he was indicted for felonious assault. His life changed. Bankruptcy, foreclosed on his house. 2 years this is languishing. And it was languishing because he was using his brother's divorce attorney and then didn't have the proper attorney. The prosecutor didn't understand that he made these statements because of the adrenaline, the norepinephrine rushing through the system, the tunnel vision, the hearing deprivation, the loss of fine motor skills. All this is happening. Tell me what happened now. These things are being screamed or being stated. He doesn't remember why he said that, but the prosecutor didn't understand this. Once I got involved, brought in the expert witness to talk to the prosecutor that I was going to bring to trial and have the defense use in trial, well, then the prosecutor understood. Okay, I understand why these things were made. That makes a lot of sense. And then the charges were dropped in that case. You're not preparing a script. I tell people, I tell clients that I've used, and when I have conversations, practice your 911 call. Why do we call 911? Does anybody know? I know you know. To summon help, that's it. We don't dial 911 to plead our case on the phone. Oh my God, I shot somebody. Why did I do this? I can't believe I shot him. We don't say, this is what happened, and we're going to want to because we're the good guys with the guns. In fact, because of everything that's going on in our bloodstream, we can't formulate the words to call 911. So I've practiced this. My name is Maloney. If it happened at home, I live at 4793 Woolridge Court. I was in fear for my life, and there's been a shooting. Send the ambulance and police. I'm 6'2", bald. I'll be in a white T-shirt and boxer shorts in my driveway. And then I hang up. And I call my attorney if I know that he's going to be here 24 hours a day and be there to answer the phone. Or, as a member of second call defense, I call that toll-free number. And there's going to be an attorney on the phone because at this point in time, you are all alone. You just knowingly, intentionally shot somebody in self-defense. But they don't get to that. The police officers don't care because they're investigating what happened. In some jurisdictions, if you're the ones who pulled the trigger, you're going downtown. In others, there's going to be an investigation, but there's always going to be an investigation, and if you have help on your side immediately, things will change. With all the phone calls I've taken and all the self-defense shootings since I started second call defense, one thing always resonates when I talk to the people when everything's over, and it's worked like it's supposed to work. The main thing that everybody has said is, I don't feel like I'm alone. When I have an attorney on the phone, when the police are questioning me and everything's happening, I'm not alone anymore. And that's the biggest feeling you have. And the police understand. They're instructed the same thing. You know, you don't make any statements until you've had opportunity to collect your thoughts and speak to an attorney. And there are constitutional rights, certainly, and we have to invoke our constitutional rights, but it's important. It's important that we understand that we're still the good guy. And we're going to be making all these bizarre statements. We're going to be screaming, my God, why did I do this? I didn't mean to do this. I didn't want to shoot somebody. Well, you didn't mean to do this and I didn't want to shoot somebody is a civil attorney's dream on a 911 call. And if any of you ever watched the George Zimmerman trial, and I tried to watch it all on YouTube, the prosecuting attorney said something that resonated with me and that I still remember. Now, you're going to hear the 911 calls. They were recorded, and they're here forever. That's what he said in his opening statement. And 5 people made 911 calls. Nobody involved in the shooting did, but these 5 people were grilled. Cross-examined, direct examination, what happened, what did you hear, what did you do? So you can imagine what's going to happen to you when you're on the stand if you make a 911 call that totally makes no sense whatsoever. And I'm telling you, I teach a seminar on the 911 call specifically, and you can hear 911 calls when the most bizarre things are being said. And I also remind people that if you make that 911 call, it's going to be tape recorded. But note, when you're put on hold, they can hear everything you're saying. I mean, you think about, why would someone be on a 911 call put me on hold? Because you'd be surprised what people think and will say when nobody can hear what's going on. And so I give that as advice that you're always on film somewhere now, and you're being recorded when you're on hold, whether you're calling a car dealership or you're calling your dentist office, when you're on hold, they can still hear what's going on. Now, the psychological response to a threatening encounter is what creates the inability for us to even know what's going on, to make a proper statement other than, police, Mr. Officer, there's the bad guy, there's the knife you tried to stab me with. Those folks are witnesses. I'll be happy to cooperate, but not until I've had the opportunity to collect my thoughts and even decide what's going on and speak to my attorney. And I'm sure you'll understand. And you know what? They will. Some of them may not, and they want to ask you questions again. That's why it's important that you have an attorney on the phone, because they give you the courage that you don't have at that point in time and remind you that you were in fear of death and serious bodily injury or harm, and that's the only reason why I would ever do something like this. So the psychological responses to a threatening encounter. We need to understand this because things are going to happen that, and I remind people, we can train and train and train, and we can't keep these things from happening. We may be able to act and shoot better when we have no fine motor skills, we have no blood in our fingers, or the adrenaline is rushing through our system, but we're never going to prevent these things from happening whatsoever. So it's important that we understand that we're going to have a rush of adrenaline immediately, and it's going to happen like that. Oftentimes, that rush of adrenaline happens before you even recognize the threat, because your brain does. You know when your hair stands up on your arms and you don't know what's going on, and then suddenly something happens? Our brains and our bodies have an innate ability to protect ourselves. So oftentimes, the rush of adrenaline is so quick, the situation hasn't even presented itself. Norepinephrine is dumped in our bloodstream. It's created by our pituitary gland because God created this unbelievable body. And this body becomes the meanest fighting machine that you can ever imagine. The rush of adrenaline and norepinephrine is going to make you stronger, quicker, faster, meaner than you ever were before in your life. And at the same time, your respiration is increasing. Your blood pressure is going up. Your capillaries at the end of your extremities are constricting, so all the blood is being forced around our organs because we're trying to protect ourselves from what might happen. The anesthetic effect that's going through our system. That bad guy that got shot in the leg and shattered his femur, he had no idea he was even shot until he tried to walk away and collapsed and didn't. That's what even the bad guys are going through. The good guys are going through the same thing. You get tunnel vision. You're only focused on the threat. You don't see everything else that's going on around you. You have hearing deprivation. You can't hear. Things become to occur in slow motion. You've lost space and time. All this is happening. Now, tell me what happened. Well, I don't know what's happening. And so because you can't formulate the words to call 911, and because you can't act properly, then we just don't do anything at all. I always say there's nothing really, as a criminal defense attorney, I'm ethically obligated to protect my clients within the bounds of the law. When I remind somebody of their constitutional rights, there are constitutional rights. You know, everybody who raised their hand in here that served in the military and they're police officers, well, they served and they fought to protect those rights because we have those rights, and our founding fathers gave us those rights, and they're not diminished by anybody and under any circumstances. So tell me what happened right now. It takes between 20 and 60 minutes for our body physically to return to pre-arousal levels. So think about that, 20 minutes to an hour. Have you ever gotten in an argument with your mom, your dad, or your brother or sister, and the argument's over and you start shaking? Well, the shaking is the adrenaline leaving your system. So even little arguments like that, you know, you're getting a dump of adrenaline. If you've been an athlete just before game time or during the plays, you're getting that dump of adrenaline. In car accidents, witness things like that, in fights, you get that rush of adrenaline. And physically it takes 20 to 60, but 60 psychologically takes hours, takes days, takes months, it takes weeks. Sometimes it never comes back. Or sometimes it comes back when you're not expecting it. That's what is responsible for a lot of the problem with PTSD. Our brain has the power to put those things aside. We don't want to think of those things. Those things nobody should ever encounter. Nobody should ever go through this, but they're forced to, and so our brain is keeping those things hidden until suddenly they're going to pop out. Oftentimes when clients walk into my office and I ask them what happened and something just happened, I hand them a tablet. And it's a little tablet, and I say, put it in your pocket with a pen. Every time you remember something, put it by your nightstand, because a lot of people remember a lot when they wake up in the morning. Write things down. And you're going to come to a point in time when you're going to say to yourself, did this happen or am I imagining it? Write it down, because we'll figure that out at the end, because a lot of this thing comes back very slowly. And it takes a while for us to understand what occurs, and unfortunately sometimes we never fully remember what occurred. And that's why one of the things I added as a benefit with the National Rifle Association and the foundation I created was the ability to have up to 45 visits or 40 visits with your own psychiatrist or psychologist, because listen folks, none of us know how we're going to react. None of us know if we can even live in the house again that we killed somebody in our foyer. So make sure that you take care of yourself psychologically, because you don't want to suffer with that your whole life. I'm on a radio show called Locked and Load Radio once a week for an hour. Bill Frady sponsors that show. Bill was involved in a shooting when he was 14 years old. It was an accidental discharge, a negligent discharge. He shot his buddy. His buddy ended up being all right, but for years he relived that. He relived the horror of that day over and over and over again. And it wasn't until after he was in the military that he sought treatment for other things, and a lot of his problems were from that day. And that was a negligent discharge, an accident, and he shot his friend. His friend recovered, but he never got over that. But because he repressed that and suppressed that in his mind, it caused a lot of problems in his lifetime. And we don't know what's going to happen. So I always encourage somebody to talk to somebody. And if you're my client, I'm going to encourage you to go out and at least spend a few hours on the couch with somebody to make sure that you can handle this the rest of your life. Because you know what? You may be acquitted, you may not be charged, but the thought of what happened continues on for a long time. Now, we know we've used lethal force because what? We are in fear of death or serious bodily injury or harm. So that's the only reason why us good guys with guns are going to use a firearm. So how are we going to be judged? If we are judged and we're judged before a jury, how are they going to do that? How are we going to slip into the skin of somebody from another state that we're not from, and how is a jury going to look at us? Well, have you ever heard of the reasonable man doctrine or the reasonable person standard? Simply what that standard is a standard by which the jury is going to deliberate how you acted were or how your reactions were to a given situation. There's a couple interesting things when we're talking about the reasonable man in a self-defense shooting. If you've ever been a jury or been on jury duty, you get jury instructions at the end of the trial. And specifically, they tell you not to slip in the shoes of the person. Don't put yourself in that person's situation, because for most cases, you're the fact finder. You're just determining who's telling the truth and who's not. You're taking the facts and you're determining which ones are the true facts. And so the instructions you get are you have to remain unbiased, except for a self-defense shooting. Generally speaking, in a self-defense shooting, the jury instructions are going to include instructions that tells you feel free to step in the shoes of the person that used self-defense. What would you have done? And that's because in plain language, what the reasonable man doctrine states is that as a juror, You want to consider what a reasonable person under the same or similar circumstances, knowing what that person knew at the time, have acted the same way and used lethal force. Would us, a reasonable person, knowing the same thing that everybody else did in the same situation, would we have acted that way? If so, we're reasonable. We reasonably use self-defense. It's simple enough. We're reasonable people. In fact, statistically, we're the safest, most law-abiding segment of society. We know that. But, and there's always a but, the self-defense shooting took place in San Francisco. We're from Kennesaw, Georgia. If anybody knows anything about Kennesaw, Georgia, you are required to own a firearm. So trust me, the reasonable person in Kennesaw, Georgia is not the reasonable person in San Francisco. We can all agree. San Francisco, by the way, got rid of their last firearms deal that there's ever been in the city. So you can't even buy a gun in San Francisco. I always say, you know what? If you're from San Francisco, I'm not picking on anybody, but you're not reasonable. You're not like me, and you're not like most of us in here. And so that's what we do. We take a jury pool, or we take a city or a township, and we take everybody's thoughts, everybody's customs, the way we've been raised, who we are, and we mold that into the perfect person. And that's the reasonable person for that jurisdiction. But keep in mind, even though two cities in Ohio, Cleveland and Cincinnati, and I'm outside of Cincinnati, I'm pretty calm and pretty safe and secure in my Second Amendment rights. Joe Dieters in Hamilton County is a great prosecutor. The prosecutor in Butler County, where I live, is a great prosecutor. The sheriffs are great. They think like me. They encourage us to be ready to protect ourselves. But if I go home to see mom and dad, I travel through Cleveland, Ohio, where if you mention a gun, it's like mentioning a bomb on an airplane. They're not like me, and they're not like us. So you need a person that can help you out, because the police, the prosecutor, and the judges, they don't have the same values, the same mores, they don't think like us. They're completely different. And that's a great example for me to use. So the reasonable person in Cincinnati, Ohio isn't the same as a reasonable person in Cleveland or Kennesaw, Georgia, and San Francisco. We're not the same. So how then do we step into the shoes of a reasonable person in San Francisco if we're from Harrisburg, Pennsylvania, or we're from New York City, or for wherever we're from? Well, that's why you have to have local counsel. Local counsel is one of the most important things that anybody can ever have. If you use a firearm in self-defense, or you're involved in anything where you need an attorney, you need an attorney from where the incident took place, no matter what the incident is, for a lot of reasons. You need an attorney that knows every nook and cranny of the courthouse. You need an attorney who probably stroked a check to the judge's campaign. You need an attorney that probably campaigned for him, that knows every bailiff, that knows every person in that courthouse, and that you're there all the time and, hey, Sean, what are you doing? What are you here for? Well, I have a self-defense shooting. It's somebody that knows the prosecutor, knows what the prosecutor thinks like, knows what the judges think like. If not, you're going to get homered. Homered is a term that we use as an attorney, that we get in there and we're not treated fairly and we're not from here. And as an attorney, either I'm not going to represent you from a jurisdiction that they don't know me in, or I'm going to serve a second chair. You're going to have one attorney who was from that area, and then I'll be offering advice and counsel at that point in time. So that's how we become that fictitious reasonable person in a city that we're not used to. So we made a decision that we're in immediate, unavoidable fear of death or serious bodily injury or harm. We are forced to use lethal force in Cleveland, Ohio. I'm from Cincinnati. How do I become the reasonable person in Cleveland, Ohio? My attorney takes care of that and molds and says, you know what, folks? I understand what you're thinking, but this person was in fear of serious bodily injury and immediate death, and there was no other choice than to do this. And that's why your local counsel is one of the most important things that you can have. And that's one of the things when I was thinking about selfishly, what do I want in something like second call defense or the NRA's endorsed insurance product, I said, you want to have the ability to have a local attorney available wherever the shooting takes place. As we travel across America, I can't imagine being on vacation and not knowing anybody. Well, if you have an attorney you can call or an organization you can call, they can give you immediate assistance, and then they can provide you with the best attorney wherever the shooting took place. So how then do we convince a jury that we acted like a reasonable person? And the jury are going to get instructions, and most of the instructions and what I'm going to talk about, you're going to find in almost every state, in almost every concealed carry handbook that the Attorney General puts out. That's why I always say, Don't take any of this as legal advice. Take it as a principled conversation, but make sure if you have specific particular questions in your state or your city that you contact a local attorney, but the tests are going to be the same no matter where you are. So we convinced the jury that we acted as a reasonable person using 3 standards: ability, opportunity, and jeopardy. The first thing we want to think about is, did the attacker possess the ability or a weapon capable of causing death or serious bodily injury or harm? Look around. What can cause that? What would give someone the ability to place you in that? It could be a chair being swung, certainly throwing me out the window, punching me if I'm smaller, a knife, a pen, a pencil, certainly a firearm, a frozen bag of squirrels, a can of soup. Now, I always say frozen bag of squirrels because there's a case that I love that was in California. There's a property dispute. I think more people have been killed in America because there was a fence line dispute than anything else. In California, someone put up a fence. They were having an argument. The argument got heated. One of the persons involved in the argument ran into his house and got a frozen bag of squirrels and beat his neighbor with them. And I point that out because that was in Nancy Pelosi's jurisdiction. She has yet to ban frozen squirrels. And I'm still waiting for that to happen, folks, right? It's got to be the firearm, but in this case, it's got to be the squirrels, but they haven't yet. But I always point out, so it can be anything. It doesn't matter what it is, but if it can cause death or serious bodily injury, then I have the ability. Certainly, if I'm standing over you right now with a knife in my hand, screaming, I'm going to kill you, I have the ability. It's right there in front of them. The next thing we have to consider is opportunity. Does the person with the knife that has the ability, do they have the opportunity right now to use it against me? Certainly if I have a knife in my hand and I'm screaming, I'm going to kill you, and I'm 100 yards away, the ability to do it is there, but the opportunity isn't quite there yet. But in that case, when I'm standing right over top of him screaming with a knife over my head, I have the ability and I have the opportunity. So does the aggressor, were they close enough to use their ability against me? Whatever that ability is, if it's a squirrel or if it's a knife, is that ability or is that opportunity there? So in my case, with a knife in my hand, that's certainly with the ability, screaming, I'm going to kill you, as I plunge downward, I have the ability and I have the opportunity because he's sitting right here. The final thing is jeopardy. Is it reasonable for you to believe that your life was in danger and jeopardy? And that's really what it is. Am I afraid? Can it be done? Jeopardy is, I'm going to read you the black letter law part of it. Jeopardy is defined as the exposure or imminence of death. There it is, immediate or imminence. I was in fear of immediate harm or death. Death of loss or injury. There it is. I was in fear of immediate serious bodily injury or harm. It's pretty imminent. He's right there in front of me with a knife above his head, screaming, I'm going to kill you. And he rushes at me, so I'm going to kill you. I get there, I have a cell phone in my hand. He shoots me. Was that reasonable? Yeah. I'm screaming, I'm going to kill you. My hand's in my jacket. I pull it out, I'm right there. Remember, death doesn't necessarily have to be the consequence. It's a subjective test. As he's sitting right there, and I'm screaming at him, I'm going to kill you, and I'm right on top of him and pull something out, what more does he have to wait? If it is a knife, he's done. So he shoots me. Remember, death doesn't have to necessarily be the final act, but it's reasonable for him to think, with all of us sitting in here, all our values, all our mores, I want you all right now to step into his shoes. Would you, facing the same facts and situations with everything that he knew sitting there looking at me, screaming him, reaching in my jacket, I'm going to kill you, pull something out of my jacket, how close is too close? Did he reasonably use a firearm in self-defense? It could easily be argued yes. And you have to remember that. And remember, it's a subjective test. What he may think is different. What I think, what she thinks, what he thinks. It's all what do you think, and reasonably, was there the ability? Yeah, I'm running right at him. Did I have the opportunity? Certainly I was right over top of him. Was he in jeopardy? Yeah, he was afraid I was going to kill him. It didn't matter that I didn't have the ability to kill him right then, because in his mind, subjectively, that was there. And so, and I feel sorry certainly for the police officers that have to live with things like that. But on a regular basis, police officers are forced to shoot sometimes young kids with airsoft guns. These guns look so real. They're responding to different cases and different things. They jump out of the car, and all of a sudden a 14-year-old runs across with something that looks just like a Beretta, and it's pointing at them. And it happens several times a year. It's the same thing. They had the ability, the opportunity, just because we didn't know that it wasn't a real gun, doesn't diminish the fact that we're in fear of our life. That immediately in fear of death or serious bodily injury or harm. So remember, death doesn't have to be the result, and in this case, the ability doesn't have to be the true ability as long as jeopardy, and we can reasonably argue, hey, I was just called to a robbery with a firearm. I got out of the car, and someone came running at me with a gun. What was I supposed to do? I was in jeopardy. I had the ability, the opportunity, and I was in fear for my life. So you have to remember that things aren't always what they seem. And you know, I always talk about what can cause grave bodily injury. Everything from a frozen squirrel to a pen to anything that someone can use, the other fist, the hands, the feet. I don't know, she could be a black belt in karate. He could have a tactical pen. And I know Judson has a frozen bag of squirrels in his, or at least fish in his bag. Now, so what makes one person pull the trigger and another person scoff at the same incident? Well, it's simply, we're all raised differently. We're a 280-pound guy. We're not afraid of much. You know, I served 3 tours in Iraq. Things don't bother me. But I'm a 98-pound woman. I'm frail. I have arthritis. I have artificial hips. We're all different. And so what causes us to act differently is that we're different people. That's why the test is always a subjective test. What would you do in knowing the facts and the situation of the feet and the shoes that you people were in? How would you react? And quite simply, that's why it's a subjective test, because it doesn't care what Judson thinks or what Aaron thinks or what you think. It cares what you subjectively think. Was I in fear of death or serious bodily injury or harm? Did I believe that he had the ability, the opportunity, and was I in fear or jeopardy? If those questions can be answered yes, then certainly you have a right to use self-defense, and certainly your actions were reasonable. So if we always look at that same fine line, if we always look at the fact that I am in fear of immediate, unavoidable death or serious bodily injury or harm, and react when we make that determination, and our brains have the ability to make it right now, then we've acted properly. And if we can look at the fact that he had the ability, he had the opportunity, and I wasn't afraid for my life, then we can properly act. I always give this presentation because I fear that when I teach concealed carry or basic pistol to become a concealed carry holder in Ohio, that the people never really think about using their firearm. That's the only way we practice, folks. We have to think, and we have to put ourselves in situations. What would I do if someone came around the corner? What would I do if someone jumped over the counter at work? What would I do if someone grabbed me when I was stepping out of my car? What would I do if someone was trying to kick my door in? We have to think about that, because that's really the only way we can practice. That's why we practice the 911 call. Because if we don't practice it in real life, when we have the norepinephrine, the adrenaline, the tunnel vision, how are we going to react if we don't train and we don't practice? So we need to practice doing that. And we need to mentally prepare to use lethal force and defend our lives, because our lives may depend on it. And practice is really simple. I always look at it as a dry fire practice for the mind. Nobody else knows what you're thinking about. So it's dry fire practice of the mind, and you need to do that. You need to have the ability to practice and train and be ready to have things go your way. Reasonableness, of course, I'm going to kill you. I'm going to come over there and kill you. And he has a cell phone, an airsoft gun, or what it is. You just got to remember that it's subjective to you, the ability, the opportunity, the jeopardy, and were you in fear of death or serious bodily injury or harm. And it's your decision and your decision alone to make that decision. That's nobody else. And I always say, make sure that you've practiced making that decision, you've thought about it, because if you're going to wait until it's time for you to use a firearm in self-defense, that you've made the decision that you're in fear of death, immediate bodily harm, right now, it's going to happen right now, and now you decide to have the discussion with yourself if you can take a human life, it's too late. What we've learned statistically from the uniform crime reports is that us law-abiding citizens, we wait too long to make the decision. We end up being harmed when really we could have reacted much, much sooner, because plain and simple, we're good guys with guns. We don't want to take another human life, but we have to be prepared if we're forced to. when it's immediate, when it's unavoidable, and we don't have a choice. So I want to go over stand your ground real quick again. Stand your ground isn't Dirty Harry. Stand your ground isn't judge and executioner. Stand your ground is the ability that once you have made the decision that you're in fear of death and serious bodily injury or harm, then you can react. Duty to retreat is once you've made that same decision, I'm in fear of death or serious bodily injury or harm, now I have to determine, is it unavoidable? Can some way, someplace, can I safely retreat? And safely means that you're not in fear or danger of any harm whatsoever, no matter how small. But remember, the threshold question is always the same before you even get to any of those considerations, and you can all say it with me right now, I was in fear of death or serious bodily injury or harm. And that's why I use the firearm or lethal force in self-defense, because I'm a good guy, and that's the only reason why I would do that. So was it imminent or not? Was it instance? Was it going to be here? Come here tomorrow at 12 o'clock and I'm going to kill you. Well, just don't show up tomorrow at 12 and that'll pretty much go away. So you got to remember, was it imminent or not? Not as soon as I cross the street and 5 or 6 rows of traffic, but certainly right in front of you, then it's pretty imminent. It's right there. Remember, when you talk about imminent or immediately or imminence, it can't be avoided. I can't scream or I can't dial 911 to have somebody else intervene on my behalf. It's right here. It's right now. I have no other choice. At this point in time, I'm going to ask some questions. I'm going to remind you that opportunity can happen at any time. Not the opportunity to use lethal force, but the opportunity for somebody else to attack you. Please remember, I can have a safety class on never, ever, ever carry on an open chamber for a number of reasons. Safety first, and then because you don't have time to react and put one in your round. If you always carry on a loaded chamber, always, your brain knows that your gun is always loaded. A loaded gun has never accidentally shot anybody. But when you start deciding that I'm going downtown tonight, so I'm going to rack one in a chamber, or today I'm going to church, so I'm not going to put one in a chamber, your brain never really knows if it's loaded or is it unloaded, because sometimes it's loaded, sometimes it's unloaded. I've had case after case after case. There's been a negligent discharge. I shot up my light switch and went through the other 2 condos. I had that happen. Well, I put my gun down and the gun went off. I said, bull crap. I said, you pulled your gun, you thought you were on an empty chamber and you dry fired, and he said, yeah. That's why, because sometimes your gun is unloaded, sometimes it's loaded, so you always load the gun, your brain always knows it's loaded, your finger never touches the trigger. It's the best advice that anybody could get. So the opportunity can occur anywhere. If you're going to your corner grocery store and you feel comfortable and you decide to leave your gun at home because nothing's going to happen, boy, I wish I had your ESP. So don't do that to yourself. Every 13 seconds in the United States, someone uses a firearm in self-defense. Statistically speaking, every 13 seconds. Now that's, hey, I have a gun, or hey, I have a gun, or boom, I have a gun. But statistically speaking, and that's what nobody hardly ever reports a brandishing. But statistically speaking, it happens that often. So 2 o'clock in the morning, you're jarred awake. You're forced to use your firearm in self-defense. Suddenly, you're a defendant in your own home, and you're being arrested. Who are you going to call? You want bond money or bail money. Have you ever gotten bail? Can your wife or your husband get bond or bail you out? Do you know how to do it? Do you know where the bail bondsmen are? Unfortunately, they're where the jails are, and if you think about where the jails are in your community, they're not in the nicest places, so you don't want to send somebody to do that, so you have to make a phone call. You have an arraignment the next morning, so you need your attorney, you got to call somebody. You want somebody to tell your wife, your kids, your family, your husband that you're going to be safe, you've been arrested and you need help, that's another phone call. Folks, that's 3 or 4 or 5 phone calls, and they are dead serious. You get one. And it's probably going to be a collect call, and if whoever's on the other end doesn't answer the phone, well, they'll bring you back a couple hours later and let you try again. But then they'll let you hear on the other end, honey, take the call, it's me, I'm in jail. So you're going to have several phone calls to make. Who's that phone call going to be? Do you know an attorney that's going to answer the phone 24 hours a day? Right now, I want you to tell me in your mind, who are you going to call if you shot somebody right now? Who's that person going to be? If you don't know who it is immediately, and you don't know they're going to answer the phone immediately, then you're out of luck. It has to be somebody you know, and unfortunately, because we travel, we're such a transient society that we have to have somebody available to us wherever the shooting takes place. And that's principally why I selfishly, remember, it was the right thing to do. I started second call defense. All these phone calls, you get to make one. 2 o'clock in the morning, you're arrested. One phone call. 911, you've already made someone help. For whatever reason, they've arrested you. Now you need bond. One phone call. You need an attorney, and you have no idea who to get for an attorney. One phone call, you have an attorney. One phone call, all your loved ones are contacted. All your emergency contact, whether it's an attorney, your brother, your mother, your father, your sister, your brother, they're called. You were involved in an accidental shooting. One phone call, you're covered. You need an attorney, you don't have money for a retainer fee. It's provided for you. Retainer fee up to $50,000, up to $100,000 of criminal coverage. The NRA provides us with unlimited civil coverage. What that means is once you get that letter in the mail that you're being sued, because even though you were cleared of all criminal wrongdoing, they're still suing you. They're trying to take your assets, your money, your savings, your 401k. The NRA provides you with unlimited civil defense fees. Whatever it costs them to protect your assets is going to be covered. We offer nationwide attorney access. We offer everything that selfishly you need. And you need, I don't care what service it is, I don't care where you do it, but please get it. Because when you need it, there isn't an attorney out there that's going to do it without a retainer fee up front. Criminal defense attorneys, we're in a bad position. We hardly ever get paid unless we collect it up front. Because if we win an acquittal, well, I wasn't guilty of anything. I shouldn't have to pay for an attorney. And of course, if we lose it and you're on the way to jail, you have no reason to pay us anyhow. So just be ready. It gets expensive. Everything from 24/7 emergency hotline, personal crisis manager, psychological help when you need it, on-site assistance if you're alone and you need somebody there, we'll send somebody there to help you choose your attorney. There's been many cases. A case that I recently had in Philadelphia, Pennsylvania, a 72-year-old gentleman was on his bicycle. He was attacked by 4 different thugs and knocked to the ground. They were surrounding him. He was a concealed carry holder. As one was right over top of him, he shot him. Well, he didn't hit anybody. Right in front of him, but who knows where his hand was when he had tunnel vision and he was looking at the person. Everybody scattered. When I took the phone call, I was on the hotline that day. He said, I just shot a kid. I'm thinking, oh my God, he just shot a kid. Well, when you're 72 years old, everybody's a kid. So it was a relief when I found out that it wasn't really a kid. But he hadn't made the 911 call yet. So we made that call together. And I just knew in Philadelphia that things weren't going to go real well. It took 52 minutes for the police to arrive in Philadelphia. That's pretty typical. And so I said, where's your firearm? On my side. Where do you normally keep it? In my drawer. Put it in the drawer. You don't need to have that firearm on you when the police arrive. That's another dynamic that you don't want to have. So the police finally get there. But by the time the police were there, I already contacted a criminal defense attorney in Philadelphia that was on the line with me that heard what was going on. After they questioned him, they took his holster, his firearm, his ammunition, his concealed carry permit. They told him to come down to the police station and wanted to ask him more questions. And I asked the police officer, he handed him the cell phone, and I said, is he under arrest? He said, no. I knew things were going to happen. Well, the police showed up again at 2 a.m. and we're going to haul him off, not under arrest, to answer questions. Had the attorney from Philadelphia go there. 20 minutes later, he called me and he said, hey, when I got to the police station, some sergeant realized and said, you did what? And they let me go. They gave him everything back but his firearm. Sent a letter 2 weeks later, he did, asking for a return of his firearm. They said even though there would be no charges filed, he did everything that he had a legal right to do, we're going to keep your gun. But if you want to appeal, this is how you do it. He was using a Ruger LCP, probably $300, $350, $380 gun. It was $500 to file the paperwork to sue. I said, we're just going to replace it. Well, I want to get those SOBs. I said, well, so do I, but sometimes just take your property back and end it. So I'll answer some questions, any questions you have particular that you want to talk about, but I also want to offer you second call defense for free. I want to give it to you for a month free. We have seminars like this and podcasts similar to this online for the members only section that you can get. You'll learn how to handle a 911 call. You'll learn different things in your area and what's going on with the law. You'll be offered seminars like this from time to time, either online or in person. It's something that I think all of us need, and I say that and I truly believe that because I'm the #1 customer. I was the first person that bought Second Call Defense and became a member of Second Call Defense because as I was teaching a basic pistol class, and I asked my students at the end, after we went over Ohio law, who are you going to call? I turned that question on myself for the first time and said, who am I going to call? Because I had never thought about that. And I always tell people, I'm a seasoned criminal defense attorney of almost 25 years, and I need help. You're going to need it too. So take advantage of the free offer. I just want it for a couple of reasons. I want you to learn about us. I want you to be protected because as a member of the National Rifle Association and a Second Amendment advocate, I know that no matter how many times a good guy uses a gun, the media is always going to turn it around if we go to trial, even when we're acquitted. if you have an attorney immediately up front when something happens, everything changes and chances are you won't be tried, and so far that's been true.
Second Call Defense is the only organization in America that offers complete legal protection for armed self-defense. Membership includes insurance backed by the NRA-endorsed insurance program administered by Lockton Affinity, LLC. As a member, you'll get up to $1 million civil defense protection, plus unlimited protection at the ultimate level. $250,000 for civil damages, $250,000 for accidental shootings, and $50,000 for criminal defense reimbursement. You'll also get non-insurance benefits, up to $25,000 immediate cash for bond, $10,000 immediate cash for attorney retainer, and $500 per day compensation while in court. And that's just the beginning. Depending on your membership level, you'll have access to a 24/7 emergency legal hotline, personal crisis manager, nationwide attorney network, local attorney referral within 24 hours, emergency contact notification, expert witness coordination, gun retrieval or replacement, psychological support, stuff hits the fan on-site assistance, and more. You get immediate, real-time legal and financial protection after you pull the trigger in self-defense. No out-of-pocket costs. Upfront cash right when you need it. Nothing to repay. Membership is available for all U.S. residents in all 50 states, including off-duty law enforcement and non-deployed military. The protection follows you anywhere and everywhere it's legal to have a gun, even when you're traveling or on vacation. And the convenient month-to-month membership puts you in control. No contracts or commitments. You can change or cancel anytime. If you own or carry a gun, you owe it to yourself and your family to be totally prepared. Second Call Defense gives you complete legal protection for armed self-defense. It's the most comprehensive protection for armed self-defense in America. Join Second Call Defense today.
Does anybody have any particular questions? Yes.
For the phrase, the fear of death or immediate fear of harm, would it be appropriate or not to have an additional ending for myself or someone else? Like if you were running at him, but he didn't have that opportunity to defend himself, but I did, and you could have went to him or someone else.
We have, in all states also, we have the ability of self-defense and defense of another. So that's always available. So, but I always tell people that if we're going to use lethal force in defense of another person, number one, we better know everything that happened from the beginning to the end, and number two, you better be willing to go to jail for that person, because if you did it improperly, that's where we'll end up. But yes, you have a right to use self-defense on behalf of another person, whether it's somebody you don't know on the street or it's a loved one or a household member, certainly. Another question? Yes.
I had a handgun. It was a Glock. I used to carry it on a regular basis, and I enjoy shooting it. Through the years, I've replaced parts on it, put aftermarket barrel, this and that. So now I don't carry it. I carry another gun because, and maybe I'm wrong, I wouldn't want to go into a courtroom and have them say that you modify your gun. Is that an issue?
You know what? People who write books and are keyboard commandos, they may write that in an article, but let's face it, if you're in fear of death or serious bodily injury or harm, you have a right to use anything you want. And maybe years ago they could be critical of the ammunition you used or something like that. But for the most part, there's really nothing that they can say, because you legally and you had a duty to protect yourself. So mostly no, because now if it has a 3-pound trigger and you're worried about hitting the trigger and it going off negligently, then yes. But really, modifications that you make to your firearm, they're not going to become an issue in court, because the real issue is, did you properly and reasonably use a firearm or lethal force in self-defense? Years and years ago, if that's the only thing the prosecutor has to go on, is that you have this gun that's modified, so you have a lighter trigger pull, or there's no slop in the trigger, so you're actually more accurate. Who wants a New York City trigger? 15 pounds, anybody? So you make it something you can shoot, and because of that, If that's all the prosecutor has to rely on, he doesn't have much of a case. Yes?
If I see somebody stealing a car out of my driveway, what options do I have?
See if he needs a credit card for gas. Because in the United States, we can't use lethal force to retrieve property. Human life has been deemed more valuable than property, the personal property or anything like that, or that fence line dispute. There was a time when that wasn't the case. There was a time when you can use lethal or deadly force to protect property. Case Catgo versus Briley, I believe was the name of it, in Iowa, years and years ago in the 40s or 50s is when the Supreme Court decided human life is more precious than any property. But there's states where you can do that, but I don't even want to discuss those. Pennsylvania, for example, you can retrieve property. So if you see your stolen property, you can go on their property, you can take it, and then if someone tries to stop you, even though you initiated it and it rises to a level you're forced to use lethal force, then you can really, even though you started it, you're still protected with the defense of self-defense. So. Yeah, I mean, do you want to live with yourself that you killed somebody because they took your car?
Well, if you fire a gun in the air, are you still liable then?
When you fire a gun anywhere, I want you to write your name on every bullet because you're responsible for every bullet that leaves your barrel. So what goes up must come down. So we never fire warning shots. We never fire a gun in the air. I mean, because we're responsible for that. Yes?
You talked about a lot of scenarios where you're outside the home, you're on the street, you're at a store, anything like that. Inside your home, is it different? I've heard a phrase called castle doctrine, where just the fact that somebody entered your home uninvited, that the use of deadly force is sometimes different.
There's 22 states in America that have the castle doctrine. And what castle doctrine says is that automatically, because you're in a home, or a home you have your home, or a home you have a legal right to be there, when someone else enters that home uninvited, then if you use a firearm in self-defense, then essentially you reasonably use that gun in self-defense. The assumption is, or the presumption is, that you legally did everything you had a right to do. And in some states, castle doctrine laws extend to the car or automobile. So if someone breaks into your house, the presumption is you reasonably use your firearm in self-defense.
You can.
And there's cases all over the country when someone's been beating in the doors, kicking in doors, and people have actually said, stay away, I have a gun, and they've shot through the door. The judges and courts have said, you know what, that's good because how close is so close? She doesn't have to wait until I have my hands around her throat to act in self-defense.
Well, a lot of burglaries happen where the people didn't realize somebody was home.
Oh, and that's mostly what happened.
And then all of a sudden, uh-oh.
Well, that's what the castle doctrine is for in the states that have them. But still, you have to be in fear of death or serious bodily injury or harm in most states to use that. But the castle doctrine says that if you do use lethal force, then you reasonably used it. But that doesn't mean it's over then. It doesn't mean the prosecutor can't prove otherwise. You're proven that you reasonably use your firearm in self-defense. And the reason why I say that, because in Ohio, we had the duty to retreat for years in our home. And I always tell somebody, now that we have the castle doctrine, just because the castle doctrine is in place doesn't mean the prosecutor is going to stop their investigation. And doesn't mean the police are going to stop their investigation because you knowingly, intentionally killed another human being in self-defense. That's a homicide. So there's still going to be an investigation, but the presumption is that you reasonably use the firearm in self-defense. And that's important in the state of Ohio because in Ohio, we're the only state of the 50 states that the burden of proof is on us first. If I use a firearm in self-defense, and I'm not in my home or my automobile, so I'm not protected by the castle doctrine, the burden is on me, the defendant, to prove that I reasonably used the firearm in self-defense. Remember, in every other state, you're presumed innocent until proven guilty. Not in Ohio, if you're using a firearm in self-defense, it's totally the opposite. But once I prove by a preponderance of the evidence, more likely than not, that I did, then the prosecution has to prove beyond a reasonable doubt that I didn't. It's just kind of a two-part test, but you are safe to assume in states where you have a castle doctrine, the presumption automatically is going to be you reasonably use your firearm in self-defense. But make sure the state that you're in has a castle doctrine. Yes?
I've read a couple articles where the criminal has actually been able to sue the homeowner. How is that possible that they actually win that case?
Well, tort reform, even if there was cases where burglars have been shot and died, and their families have sued the person who did it because, you know what, my dad, burglarized for a living. Well, he can't do that anymore. Simply, it's being a little facetious, but someone's dead, someone's injured, and civilly, you didn't have a right to do it because you know what? You were screaming, my God, I wish I hadn't done that. Why'd I have to shoot that person? And there's always an attorney out there that'll try to take a case. Most of those cases get tossed out, but the fact that they get tossed out, you still have money outlaying to defend yourself. And unfortunately, there's still some states without castle doctrines that the ability does. So for Ohio, for instance, if I'm in my home and I shoot somebody and I was justified in shooting somebody, they're barred from suing me. But yes, they can do that. But we're in a country, a litigious society, where you can be sued for anything or nothing. Well, think about the McDonald's hot cup of coffee. Oh my God. So please take advantage. I'm going to give you a month of second call defense free. Aaron's back there. We have applications everywhere. I'm at the booth to do it. But I encourage everybody to do it because you know what? You don't know what you don't know yet. Trust me, I didn't know what I didn't know until I got involved with this heavily. Any other questions? What booth are we at? 380. We're in booth number 380. Yes.
If somebody came in here with a rifle, assault rifle, I don't know how many have pistols here, but should I avoid and run for the door, or should I pull? I may get shot.
Well, that's why I said, and folks, what is the best gunfight you've ever been in? The one you've never been in. And in a situation like that, certainly, I know there's people in here carrying firearms, and I hope everybody is. That's my hope. But there comes a point in time where you got to make a decision. Certainly, to protect your life and the lives of others, you have the choice to make. If you can safely retreat, well, you just saved your life. But if you decide you want to stay and fight to save other lives, then that's up to you. Yes?
In the same vein, for all these entities, whether it's employers or restaurants or wherever that are demanding that you not be armed when you go into their facilities, is there any burden of liability on them for your protection because of the fact that they told you must be disarmed?
I thought there was going to be a lawsuit with the Colorado shooting. I think there probably might have been, but there might have been a settlement behind the scenes that nobody knows about. But certainly I think they do have liability because when you're taking away someone's ability to protect themselves, in my mind, there's different kinds of law and civil law that protect us. One of the highest standards is a common carrier. If you're a bus driver or an airline pilot and I get on your plane or in your bus, I'm saying, here I am, you have the highest duty to protect me now because you're in charge. Now, if I'm a business invitee, you open your doors for business and are inviting me in, you still owe me a standard of care to make sure it can be done safely. So in my mind, and I'm surprised it hasn't happened yet, if you put a no gun sign up, well, then that means you're taking on your own liability to protect me against whatever that may be. And if you look at no gun signs, in Ohio, they almost have no force. Because in Ohio, when you see a no gun sign, simply stated, you have to knowingly violate it. And the only way that the store owner can know I knowingly violated it was if I said, hey, I saw the sign, I ignored it, and I came by. Other than that, how does anybody know my mental state? So yet, in 11 years, concealed carry has been in Ohio. To my knowledge, there's never been anybody arrested and certainly successfully prosecuted for that, for no gun sign. But to answer your question, yes, I would assume that they have some liability because, especially in a store, you're telling me that I have a duty to protect you and now I can't protect myself that you would.
You're also saying it's an invitation. The sign of no gun saying,
well, I go from school district to school district and speak in executive session about arming their teachers and something they want to do. And I always say the first thing I would do was take your no gun sign off the wall. That's an open invitation. If you look, everywhere from Sandy Hook to Virginia Tech to Albion, Pennsylvania, no firearms. The only people that live by those signs are us, the good guy with the gun. I know that we got to get out of here soon. Aaron's back there with applications. Take the time to put your name down and get a free month of second call defense. And if I can help you with anything, come on up here. I have business cards with my cell phone number on it. Feel free to call me anytime if you have any questions. But thank you for coming, and I hope this helped.
Thank you.
Yeah, please take the time to fill out the survey also. I want to come back. In past years, we did more than one.
I always have a question.
First, thank you for your service.
Well, it's a constitutional right. Now, a right is not a privilege. You have it. It's yours. They can't take it away from you. They didn't give it to you. How come they can send you to jail?
Sometime along the line, someone determined that the state could reasonably regulate our constitutional rights. I don't believe in them. If they truly, if you would have looked at the companion decision that I'll think about the Supreme Court justice who wrote it, and in Heller case. Can't remember which judge it was, which justice. He was interpreting the Second Amendment using the 10th and 14th Amendments. That's the way it was supposed to be done. 10th Amendment is everything not enacted by the federal government is the states can take care of. Well, our Constitution, right? Exactly, exactly, and it does trump, and that's what they didn't do. So they say they can reasonably regulate any rights. Well, you know, I'm a constitutional person.
It's not a right then. It's like I'm from New Jersey.
Right. Well, I understand completely.
I've got a Utah carry permit. It's not good in New Jersey. It's in a lot of other places. I'm interested in your insurance anyway, but that's the thing is, it's.
I agree with you 100%. Why were you in Vietnam? No matter where you were there still protecting my rights.
I missed Nam by 1 hour. How's that for being fair?
And
I was in the Med when the Gulf of Tonkin incident happened. They were ready to send us to Vietnam. We spent 3 days off the Suez Canal under 1 hour orders to be for Nam. And I got out just before.
So, well, thank you for your service.
From 61 to 67.
And never stop beating those drums. It's true. It's a constitutional right. And the thing is, it's an inalienable right, so it's a God-given right.
That's right.
Government didn't give a right. And it's reminding them what our civil rights did was remind the government of their limits.
Yeah.
Didn't give us anything. We already had it. God gave it to us.
Right.
So, thank you.
And thank you. Yeah. But you understand.
Yeah, I understand completely.
I upset my wife.
I fight that battle all the time, every day.
Yeah.
Hi.
Hello.
Where are you guys from?
Huntington.
Okay.
2 hours away.
Now you here multiple times?
We've been to this like 5 years. The
Okay.
first time we've ever come in to one of these seminars.
I'm glad you came. We have last year I couldn't make it. The year before that I did 3 different seminars. One in the morning, one in the afternoon, then a different seminar the next day, and people are always coming. Next year that's the way it's going to be. Somebody else took over, and I think that's why the seminars are like that. But I do a seminar on lethal force and the law, the 10 things you never want to do after you use your firearm in self-defense, stealing from tidying up your home, moving evidence and things like that. And then I do a great one on 911 calls, where you hear actual 911 calls, and you hear people disrupting you on the phone. Well, how'd they get here? Did they drive or did they walk? And they're still in the house. Well, how do I know? So that's another good seminar that we do.
My dad was shot on our front porch 14 years ago. So.
Did he live?
Yeah, luckily. Okay. He was shot through both legs with a 30-aught. He's still.
You guys, I'm just getting out of the way, so feel free to come on over. Uh-huh.
Thank you.
And I'm at 380 if you want to ask any other questions or everything, please come on over.
Yeah. He got lucky that he had a pacemaker put in right before that, and it kept him alive.
Oh, really?
He bled out to the point where he just had plasma coming out, and they were like, if it wasn't for your pacemaker, you wouldn't have made it.
Isn't that amazing? Now, what do you guys do?
He works.
Now, I know you're a mom, and you're probably at home right now with somebody that little.
He works as a trust builder.
Okay. You guys busy?
Nope.
How busy not that busy? Where I thought things were picking up.
Well, he's getting ready to be a crew leader, so he's lucky not to be laid off.
Now, there was a time not that long ago when you guys were probably working 24 hours a day, weren't you? Because, well, you know what? Depends when you work, because I can remember.
From August till almost November, we were working 6 days a week.
Right.
6 in the morning till about.
Mostly commercial jobs, or are you doing a lot of residential?
Everything. Major multi-million-dollar contractors that blow smoke from Idaho needing 5 roof trusses.
When I first got to law school, my first job was with construction companies. I was in-house counsel. So people who work in the construction.
Should I fill this up with a pen?
Yeah. Either way, we got a info guy that just plugged it all into the computer tonight.
every time something happens, and they say, oh, the guns.
Yeah. It's always the guns.
Radio talk shows down there. and we had to get it done somehow, and so the Buckeye was formed. I'm also a member of the FASTER team in Ohio, and it's Faculty Administrator Safety and Emergency Response Training. And really what that is a polite way and a politically correct way to say we arm school districts. In the state of Ohio, the law is that if a school board, if a school district wants to allow guns within their school safety zone, the federal school safety zone, they can. And then it goes further and allows the school district to choose who's going to carry a firearm within a school safety zone, whether it's janitors, teachers, principals, bus drivers. But after Sandy Hook, we knew one thing. The only way to stop a bad guy with a gun is with a good guy with a gun, and seconds count. And so, you know, that was started, and I can remember the media laughed at us. You're never going to get 23 teachers to sign up for a course. Well, in 2 days, we had 1,400 teachers signed up. And it's been doing that ever since. And the good thing about that is Pennsylvania, I spoke to the Pennsylvania Senate leaders last year, Jim Irvine and I did, to try to bring it there. There's interest in North and South Carolina. Justin Crossland, who's our cameraman, is spearheading the effort in Colorado. And so it's spreading because people are realizing, you know, why are we thinking about 911? Why are we thinking about a no gun sign? That doesn't stop anything. So I've been heavily involved with that. And then because of my frustration and because of the way my friends, good guys with guns, were being treated, I decided to form a thing called Second Call Defense. And I did that because, more importantly, because I was selfish. And people say, what do you mean you're selfish? Well, if you don't have bond money, where am I when I'm getting you ready for your first court appearance? I'm in jail. I don't like being in jail. And I'm in jail more often than I want to be because people just simply don't have $10,000 cash to get bonded. And then even more importantly, if they did, they're in jail, how do you get it? And then if you do have $10,000, what happens to that bond money? It goes away. You don't get that back, and people don't understand that. You're paying $10,000 for somebody to post a $100,000 bond. They're taking your $10,000 because they're posting a $100,000 bond, and I always say, why use your money to do it? If there's somebody else that'll pay for it, then go ahead and do that. And in certain situations that happened over my legal career is what caused me really to look forward and start doing that. So we'll have a question and answer period at the end, but if for whatever reason there's something that you just can't wait for, because I know there's some of you out there, go ahead and raise your hand, but trust me, I'll stay as long as you want me to stay, and I'm in booth 380, and you can always come up, and I will pass out business cards, and my cell phone's on it. Call me 24 hours a day, no matter what the problem is. I don't sleep a whole lot anyhow, so you're not going to hurt my feelings if it's 2 or 3 in the morning, and my wife's used to it too. So we're going to talk about what is lethal force. Lethal or deadly force is a force likely or intended to cause death or great harm. And we're going to show a video right now that's a series of videos of what happened to people throughout the United States when they've been forced to use lethal or deadly force. And they've truly been good guys with guns, and you'll hear what's happened, and one of them happened in Ohio that I can expand on also. And some of them are rather famous cases. Harold Fish case, for instance, out of Arizona. The only reason why Harold Fish spent 3 years in prison, and the only reason why Harold Fish was prosecuted or persecuted was because he was in a county with a prosecutor that was up for re-election. He wanted to make a name for himself. The prosecutor was so wrong in what he did, Harold Fish was released from prison, was never retried, and the prosecutor was tried and convicted of prosecutorial misconduct and was serving time. So that's how bad it got for him. I'm not saying prosecutors are bad. I'm not saying certain attorneys are bad, but I'm saying with good guys with guns, things aren't enforced equally throughout the United States, so we have to be prepared, because the good guys with the guns, we're now the safest, most law-abiding segment of society. The Uniform Crime Reports, the CDC track all that. That's what's so good about being a gun advocate, because all the facts are on our side, all the statistics are on our side, and we've been carrying everywhere. So all the stories of the blood running in the streets, it didn't happen. Judson?
Harold Fish was a 57-year-old retired high school teacher in Arizona with a clean record and a license to carry a concealed weapon. While hiking, a man charged him, waving his arms and threatening to kill him. Harold Fish shot the man in self-defense. A jury found him guilty of second-degree murder, and he spent 3 years in prison and $500,000 in legal fees before the conviction was reversed. Carl Kozlowski was a 53-year-old Cleveland, Ohio man While on an all-night crack binge, a convicted murderer broke down Kozlowski's door and began beating his girlfriend. Kozlowski shot the man with a .38 caliber revolver and was convicted of murder and sentenced to 18 years to life. It took 2 years for the verdict to be overturned and another year for Kozlowski to be released on a $10,000 bond. J. Rodney Lewis was a 49-year-old former law enforcement officer in Iowa with a permit to carry a concealed weapon. While driving home one night, he was confronted by 2 men. One, a drunk convicted felon. After using his gun in self-defense, Lewis was arrested and jailed with bond set at $225,000. A jury found that he acted appropriately, but he spent 112 days in jail, lost his job and all his possessions, and found himself homeless and penniless.
I always point those out because essentially the facts showed that they were all innocent right from the beginning. But proper representation, political motivation from one side or the other, all changed the results of that. And then when they went up in appeal and other eyes took a look at it, obviously these are wrong. And the Supreme Court with Carl Kozlowski, for example, in Cleveland, Ohio, the trial was such a sham, things were so erroneous, but again, it's Cleveland, Ohio, just progressively anti-gun, that he was convicted. It took about a year for that to even get to the Supreme Court of Ohio. The Supreme Court of Ohio looked at it and immediately ordered his release. As soon as the release was ordered, the prosecutor didn't release him and didn't order the jail to release him. The prosecutor re-indicted him automatically and went and let him out. And it took the Supreme Court again to say, no, we said now, let him out. And then so they let him out on a $10,000 bond. But it's not because, that's sometimes the way it happens. And I tell people, if you're going to carry a firearm for self-defense, know the laws. And the first thing as an NRE instructor also that I realize is that sometimes, we train and we get ready to use a firearm in self-defense and we're mentally prepared to protect ourselves or our family to do that. But have we ever asked ourselves the question, legally, when is it permissible for me to use lethal force? And that's what today's about. The broad line rule is when it's okay for you to use lethal force. Statistically speaking, we, the good guys with the gun, we wait too long. We wait till the very last moment, and sometimes too late, again, because we're the good people with the firearms, we're the good guy with the gun. So lethal deadly force is a force likely or intended to cause great harm. Now, likely I said intended. Death doesn't necessarily have to be a consequence of something like that. It just has to be a potential. I mean, certainly we can assume that we're going to be suffering some pretty serious damage if someone's attacking us with a baseball bat, but death doesn't have to be a certainty at all, but I can assume that maybe someone's going to hit me in the head with that baseball bat, and certainly I'm going to die. It's reasonable to think, and note that word reasonable, that along with a broken arm, I could be struck in the head or something else could happen, and certainly I could suffer serious bodily injury or then death. The force intended, likely or intended to cause death or great harm. Now, probably if we've read any self-defense statutes, even our own, we've heard that before, because almost every statute dealing with lethal force found in every state always has it that the person is not at fault for creating the situation first, and that person reasonably or honestly believes that he is in immediate, unavoidable danger of death or serious bodily injury. And that's what we have to look at. The first thing is, when I talk about you didn't start it, we can't start the fight and have it elevate to the point in time where we're in fear for our life and then use self-defense or lethal force. We started it, and in most states, you can't start a fight, have it elevate to, this guy's really beating the heck out of me, I think he's going to kill me, and then we can't draw it. We started it, so we can't end it. Now, the exception to that, and it's a pretty clear exception, if I break away and say, I'm done, I don't want any more of this, leave me alone, and I try to leave or attempt to leave, and then the person that is reacting to my assault will not disengage and will not stop, and then legally I'm allowed to respond with lethal force at that point in time. That's just the law. Something like that probably, certainly anybody in this room, we're not going to be exposed to something like that, but I always point that out because it's the law. So always, our response to why did you use lethal force, why did you kill another human being, is always I was in fear of immediate, unavoidable death or serious bodily injury. always the same. Why would any good guy with a gun or good gal with a gun in here use lethal force? Because we're in fear of immediate, unavoidable death or serious bodily injury. Now, depending upon the state you're in, unavoidable you may not have to use, and I throw unavoidable in there for those states where you have a duty to retreat. Because if there is some way to avoid it, then you have a duty to do that. But there's 22 states roughly without that duty to retreat, and I'll give you a quick list of some of those coming up. But I always say, why unavoidable? It covers you in those duty to retreat states, but I would say there's really nothing else to say. It says it all. I mean, and I'm in fear of immediate unavoidable death or serious bodily injury or harm. And I'll give you examples of that. When we talk about either stand your ground or a duty to retreat state, or can we use lethal force in self-defense? He hates me when I start walking around, by the way. I'm ADHD and everything else you can imagine, so it's hard to do this, so I'll try to stay here. But when we talk about that, really nothing can happen as far as us using our firearms until we make that threshold question, I'm in immediate unavoidable fear of death or serious bodily injury. It's right now, he's going to kill me or she's going to kill me. That's immediate. And we'll talk about that more later, but that's a threshold question that we have to understand, and I'm going to keep repeating that until you can recite to me that I was in fear of immediate death and unavoidable serious bodily injury or harm. Well, I was in fear of death, serious bodily harm. That's the reason. That's the bright line rule. And whether you're in a duty to retreat state or a stand your ground state, which I'll give you a better definition of in a few minutes, nothing can happen until we make that decision. That's a decision that we all have to consider. Am I in fear of death or serious bodily injury or harm? Not that he's taken my TV out of my room, not that he's stealing my car, not that he's running away now and he picked apples from my tree. A case, Catgo versus Briley, in Iowa many, many years ago, the United States Supreme Court determined that human life is more important than any property or personal property or land. So only if we can answer that question can lethal force be used. Some states allow the use of lethal force for crime prevention. For example, I was giving the same seminar in Arizona, and going through their statute, I realized that they had some strange things. Not only could I use lethal force if I was in fear of death or serious bodily injury or harm, they outlined 10 felonies that if I came upon, I could use lethal force, even though I may not be in fear. For example, arson. If I come upon somebody starting a house on fire or committing arson in an inhabited dwelling, I can use lethal force to stop it. If I walk in on certain kinds of burglary, I can use lethal force to stop it. If I walk in on child molestation or child rape, or rape, and ladies, rape is always serious injury, is always death or serious bodily injury. So that question has always been answered. So you can stop for that, but then they note it's not retribution. I mean, you can't, once it's over, and that answers the question, what if they're running away? Well, if they're running away, you know, it's done. Can everybody hear me all right? Because I don't have the mic on, so I can make it louder if you want. You want to memorize it, you want to practice saying it, and I always use the example, honey, what do you want for dinner? And the response is, I was afraid of death and serious bodily injury or harm. It has to be that much. You have to use it like that. And you know, it's funny when you say that, but you need to have that on the tip of your tongue because we're going to talk about the physical and psychological reactions to a threatening encounter, and you're going to understand that you're not going to have the ability to speak, much less be able to formulate what just happened. And we'll talk about the 911 call and how to handle that also. So as I was in fear of immediate, unavoidable death or serious bodily injury or harm, because memorize it, practice saying it. If you don't do this, nobody, and I mean nobody, will have any idea what's going to come out of your mouth. Trust me. I've spent 25 years representing people that have made the most bizarre statements in the world and have no recollection of doing that. One of my favorite ones is he's bleeding like a stuck pig. I should have shot him again. I hope you bleed to death. He makes that statement, and it was an unauthorized self-defense shooting. I'll give you the facts of the case. There was a husband and wife unlocking their front door. The man was attacked and was being pummeled and knocked to the ground. Well, he had just had open heart surgery, so his body is full of blood thinners anyhow, and he's thinking, my God, I'm going to bruise, I'm going to die. He was a concealed carry holder in Pennsylvania. He struggled and while he was being beaten, and he managed to get to his firearm. And he fired the firearm in self-defense, and when he did, he shattered the bad guy's femur. Now, bad guy is on the ground, bleeding. He stopped struggling and fighting. Wife is on 911 call, applying direct pressure to the guy who just tried to kill him's leg, because we're good guys with the guns. So we just stopped the threat. The wife was on the phone, applying direct pressure. The husband is in the truck putting his firearm away because he doesn't want to have the gun in his hand when the police roll up, and that's a smart thing to do. Well, while he was putting that away, he was screaming, "You son of a bitch, I hope you bleed to death. You're bleeding like a stuck pig. I should have shot you again." Well, the prosecutor got that. The police came up, they investigated what happened, they didn't charge anybody. But then the 911 tape comes out, and the prosecutor hears this 911 tape. And he can say, without a doubt, that the facts of the shooting was perfect, but he couldn't explain these statements that he heard in the background. Why were you saying these things? Without an attorney at that point in time, the guy says, "I don't know, I don't even recall saying something like that." So in the prosecutor's mind, it was self-defense, but he couldn't explain away these comments, and so he's thinking, do they know each other? Did they have a prior history? Is there something that they're not telling us? And so he was indicted by a grand jury. The prosecutor sought an indictment and successfully achieved that indictment. And then for about 2 years, it kind of floundered back and forth in court. The bad part was the defendant in this case, or the good guy with the gun, he got the wrong attorney. He got his brother's divorce attorney, thought it was going to be okay. So he had the wrong attorney, and for 2 years, this language went back and forth, and the husband and wife lost that house they were trying to get into in foreclosure because someone's charged with attempted murder. I don't want you as an employee, and it goes on and on and on. Legal fees, attorney's fees, and they're living with her son. And then I got involved, and I got the call, and I actually got involved by Dick Heller versus Washington, D.C., found out about that, and Dick gave me a call and said, "Can you do anything?" And then I stepped in and took a look at things and had some conversations and traveled to Pennsylvania. Pro hoc vice, which is a Latin term I was allowed to practice even though I'm not admitted to Pennsylvania. And I sat down and had a conversation with the prosecutor. And I was also available, or also had the opportunity to be in the room and present when there was a cross-examination done at a show cause hearing then sometime later for the person that was shot. And the prosecutor said I just couldn't explain it. I brought in books and tapes, and I discussed things and the psychological and physical aspects of a threatening encounter. Prosecutor began to understand, and then eventually it went away after a couple weeks. But what was interesting enough, one thing I left out is that the defendant in this case, remember when I say the defendant, it's a good guy with a gun, it's the homeowner. The guy attacked because we're defendants, they're a victim. If someone kicks your front door open at 2 o'clock in the morning and you shoot that person to stop the threat because they're coming up the stairs with you, at you, you're the defendant. 30 seconds ago, you were sound asleep, and the person who kicks your door open is the victim. That's where we all start until things are straightened out. So at this point in time, what I didn't tell you was he fired a warning shot. And what's interesting about the warning shot is that the bad guy testified he never heard the warning shot. In fact, the bad guy didn't even know he was shot until he tried to get up and walk away. So think about that. You just got shot, your femur's been shattered, but because of those same physical and psychological aspects of a threatening encounter, the norepinephrine, the adrenaline, the anesthetic that your body releases, he didn't even know he was shot. So that's a couple lessons. Granted, you shoot somebody, they may not even know it, and number two, you never want to fire a warning shot because probably they're not going to hear it. And remember, every bullet that leaves your barrel has your name on it, and you better be sure where it's going. So you're not preparing a script when you're talking to a 911 operator. If I was forced to shoot somebody in self-defense in my house, for example, let's say it's 2 o'clock in the morning, 2 o'clock this morning. Let's say instead of being in a cozy hotel room in Harrisburg, I was home. Suddenly I was jarred awake, and I don't know why, but I know something's not right. So I grab my firearm, I check my wife, she's in bed beside me, I'll wake her up and tell her to call 911, and I go down the hallway to make sure my kids are all right. They're all sound asleep in bed. So everybody I care about and everybody I love is now with me on the top floor. I have no reason to go downstairs looking for trouble, and I wouldn't. But I look around the corner and suddenly someone is rushing up the stairs at me. There's something in their hand. I don't know what it is, and I'm screaming, "Stop, I have a gun," and boom! I'm forced to shoot. The moment I pull the trigger, and remember 30 seconds ago I was sound asleep, I'm the defendant in my own home. And whoever I shot is now the victim, and now what do? Well, we call 911 because we've been trained over and over again from kids in school, call 911 if you need help. Well, eventually the help's going to get there, and I'll give you some situations with that. But then I'm forced to make a 911 call. And the 911 operator is not necessarily out to get you, but the things that we say are going to get us because we have no idea what we're saying. So we practice making a 911 call because there's only one purpose of the 911 call. Does anybody know what it is? It's obvious. It's to summon help. We summon help. We're not there to plead our case. Oh my God, I wish I wouldn't have do that. Why did I have to shoot somebody? Why did I have to kill somebody? Why did I do this? Well, you better be able to answer the question why. Well, we're just saying that as human beings. And so for me, I would say my name is Sean Maloney. I live at 4793 Woolridge Court. I was in fear for my life and there's been a shooting, sent an ambulance and police. I'm 6'2", I'm bald, I'm in a white t-shirt and boxer shorts, and I'll be in the driveway. And I hang up. Why do I hang up? Because hopefully you have an attorney you can call right that time to calm you down, to remind you what your rights are, because you're going to be running 100 miles a minute, and trust me, not only are you going to be making a statement, you son of a bitch, I should have shot you again, but who knows what you're going to be saying, because as human beings, we're trying to recover from what just happened. So what creates the need to practice? Well, the psychological responses to a threatening encounter. Now, some of you may have already heard of some of these things. Maybe you had a concealed carry course or defensive handgun course, or you read about what happens in a threatening encounter. Well, the first thing that's going to happen is you're going to have a rush of adrenaline, and that's going to be immediate. It's going to dump into your body, and oftentimes that adrenaline is dumping in your body before you cognitively realize that something's wrong. You know when the hair's standing up